The story begins not with a crime, but with a silence that stretched across boardrooms, courtrooms, private jets, and gated islands. For years, documents existed that few people saw and fewer understood. Files that moved slowly through legal systems, locked behind sealed orders, redactions, and procedural delays. According to records, these documents contain names, dates, travel logs, financial transfers, and sworn statements. What made them dangerous was not only what they said, but what they implied. They suggested a world where power insulated itself, where influence blurred accountability, and where truth was postponed indefinitely. Jeffrey Epstein first appeared in public records as a financier with unusual access. Reports suggest his wealth was difficult to trace, his client list opaque, and his rise unusually rapid. According to financial filings, his early career did not clearly explain the scale of his assets. Yet he moved easily among political figures, academics, royalty, and business leaders. Documents indicate he owned multiple properties, including a private island, a Manhattan mansion, and residences in New Mexico and Florida. Each location later appeared in investigative reports, witness statements, or court filings. In the late 1990s and early 2000s, law enforcement records began to quietly accumulate. Complaints were filed, interviews were conducted. According to police reports, several young women described similar patterns of behavior, similar locations, similar intermediaries. These reports existed long before the public paid attention. Prosecutors gathered material. Investigators mapped timelines, yet progress was slow, fragmented, and often interrupted. Court documents show that in 2008, a plea agreement was reached in Florida. The deal limited charges and reduced potential exposure. According to legal experts, the agreement was highly unusual in scope. It involved federal and state coordination, non-prosecution provisions, and confidentiality clauses. Many of the victims later stated they were not informed in advance. This agreement became one of the most scrutinized legal documents in the case, cited repeatedly in later filings and media investigations. After the plea deal, Epstein largely disappeared from mainstream scrutiny. He continued to travel. Flight logs, later released in civil cases, indicate repeated international trips. Manifests listed prominent names, staff, and associates. According to records, some flights went to destinations associated with his properties. Others went to major cities where meetings were reportedly held. The significance of these logs lies not in proof of wrongdoing by passengers, but in the access they illustrate. They showed proximity, opportunity, and a network that spanned continents. Behind closed doors, civil litigation continued, sealed filings accumulated, depositions were taken under oath. According to court records, some of these materials were placed under protective orders, limiting public access. Judges cited privacy concerns, ongoing investigations, and the complexity of the cases. Over time, the volume of sealed material grew. Journalists later referred to this growing archive as a shadow record of the case. In 2015, investigative reporting began to revisit the story. Articles cited newly obtained documents and interviewed former victims. These reports suggested that earlier investigations had been incomplete. They raised questions about prosecutorial discretion and institutional reluctance. According to those reports, some law enforcement officials had expressed internal concerns years earlier, concerns that did not lead to decisive action. Civil lawsuits filed by accusers sought damages and disclosure. In these cases, Epstein invoked the Fifth Amendment repeatedly during depositions, according to transcripts. His refusal to answer questions under oath became part of the public record. Judges noted the pattern but allowed proceedings to continue. Each refusal added to the perception of withheld information. In 2019, federal authorities arrested Epstein on charges related to sex trafficking. The indictment referenced conduct spanning years and involving multiple victims. According to the charging documents, prosecutors believed additional evidence existed beyond what had already been disclosed. Bail hearings revealed details about properties, surveillance systems, and alleged facilitators. The case drew international attention. Then, in August 2019, Epstein was found dead in his jail cell. The official ruling was suicide. According to the Department of Justice, multiple failures occurred within the detention facility. Cameras malfunctioned. Guards reportedly fell asleep. Procedures were not followed. These findings were documented in internal reviews. Despite official conclusions, public skepticism remained high. With Epstein's death, criminal proceedings ended, but the documents did not disappear. In fact, attention shifted toward them. The question became not only what Epstein had done, but who else might be referenced within the files. Civil cases continued against his estate. Judges revisited sealing orders. Media organizations filed motions to unseal records. In subsequent years, thousands of pages were gradually released. According to court clerks, these releases were the result of lengthy legal battles. Names appeared often without context. Some were redacted, others were not. Legal experts cautioned that inclusion in a document did not imply guilt. Many individuals named denied wrongdoing. Still, the sheer number of references fueled speculation. The files included emails, contact lists, calendars, and testimony. According to analysts, these materials showed how Epstein maintained relationships. He hosted dinners, funded projects, and offered introductions. Some communications suggested attempts to leverage influence. Others showed routine social interactions. Distinguishing between the two became difficult. One recurring theme in the documents was silence. Non-disclosure agreements were common. Settlements included confidentiality clauses. According to victims' attorneys, these clauses limited public understanding. In some cases, records indicate that payments were structured to avoid scrutiny. Financial experts later analyzed these transactions, noting their complexity. Another theme was delay. Motions, appeals, jurisdictional disputes, and procedural challenges slowed disclosure. According to legal timelines, some records took more than a decade to surface. During that time, memories faded, witnesses moved on, and opportunities for accountability narrowed. International dimensions further complicated matters. Epstein maintained connections abroad. According to travel records and business filings, his activities intersected with foreign jurisdictions. This raised questions about cooperation between governments. Some records referenced meetings outside the United States, where legal standards differed. As more documents became public, narratives diverged. Some focused on systemic failure. Others emphasized individual responsibility. Reports suggested that institutions prioritized reputation management over transparency. Internal memos, later cited in investigative pieces, hinted at concerns about political fallout. The role of intermediaries also emerged. According to testimony, certain individuals acted as recruiters, schedulers, or gatekeepers. Their actions were described in depositions and affidavits. Some faced charges, others did not. The criteria for prosecution were not always clear. Media coverage intensified. Each new release generated headlines, yet experts repeatedly warned against drawing conclusions without corroboration. Documents can suggest but not prove. Allegations require evidence tested in court. In many cases, that process never occurred. The Epstein files became a symbol, not just of one man's crimes, but of how power can distort systems. According to sociologists, such cases reveal patterns, asymmetries of influence, barriers to reporting, and institutional inertia. The files illustrated these dynamics in granular detail. Even after major releases, questions remained. Some documents were still sealed, others were heavily redacted. Judges cited ongoing privacy concerns and the rights of third parties. Transparency advocates argued that public interest outweighed these concerns. The debate continues. What is known is pieced together from records, testimony, and reporting. What remains unknown is suggested by gaps, missing emails, unreleased exhibits, unanswered questions. According to investigators, these gaps are not unusual in complex cases, but their presence fuels mistrust. The files also prompted broader conversations about accountability, how deals are made, how cases are prioritized, how victims are treated. Legislative hearings referenced the case when discussing reforms. Policy proposals cited it as an example of what can go wrong. Years later, the Epstein files are still being examined. Journalists continue to analyze them. Lawyers continue to argue over them. For many, they represent unfinished business. According to those who have studied the records, the full story may never be known. What remains is a paper trail, a trail that shows meetings and money, access and avoidance, a trail that raises questions without always providing answers. In the end, the files do not speak, they wait, and in their silence, they continue to unsettle those who read them.